Thank you very much, Mr. Williams. Um, and I'm grateful to Advocate Joseph Abraham, the Pravasi legal head, and Melvin, and all of you, and especially before even I say anything, I have to congratulate and appreciate you all looking after the welfare of overseas NRI, our labor force, especially what I have done when I arrived to this country as a migrant laborer. I did not know. I didn't have a clue what is all right and how can I raise my own voice in where I work. But I think in that respect, Pravasi Malayali is doing a wonderful and a brilliant, fantastic job raising their concerns in our country, especially the Middle East. They have less employment protection. However, you are trying your level best to get their voice heard in our judicial system in India. And I have to salute you and I have to congratulate you for all the hard work what you are doing, and especially the working, not the business, the business elites, but for the common workers. Their concern has to be heard, and the work you are doing is tremendous, absolutely fantastic. Now, the debate, the topic I was going to talk about is COVID-19 and employment law rights here in this country. What the British government have done in light of COVID-19, what they have done, they have implemented a scheme which is job retention scheme. We call it, in other words, furlough. When the outbreak of COVID, the employers were panicking because they were having lack of employment or they were having lack of orders, and a kind of redundancy situation where the employees was facing difficulty to pay them. So what the government did, they step in and they have said you can furlough employees, but you let them go home and we will pay you. We will pay you 80% of your wages, or 2,500, whichever is lower. That is a protection for all employees. And when a employer has to take a call on as to whether they should furlough an employee or not, it is employer's decision. If they furlough, the employee cannot work during that period for the employer. They have to stay home. They have to pay. The employer cannot work for the employee cannot work for the employer. An employer has to simply make an application to the HMRC, the state treasury, and they will pay the number of how many number of employees you are going to furlough, and their 80% of their wages to be paid to the employer, and employer then pay to the employee. You see, there are legal issues and legal concerns within, various issues are raised by various lawyers. During this stage, can they take annual leave? Some lawyers argue that yes, they can, and some lawyers say they can't. But the fact is that even if the employer is going to allow employee to take annual leave, in fact, what is going to happen? The employer must pay the full employee, the full wages for those period, for the time they sit home and not attend work. However, if they were to go according to the employee, the furlough scheme, they only have to pay 80%, and this 80% will be paid by the state to the employer and then to the employee. Almost all in all employment establishment, not only in England, and I don't know what's the ground reality when it comes to the employment law and employment rights protection in India. Here we have a situation. The employment has ceased, or diminution of the work they were asked to do has been reduced. So it's a clear stage of redundancy. The criteria for redundancy, this statutory criteria for redundancy has been attained. the question was raised whether if an employer were to redundant employee, of course the redundancy payment has to be paid. If to avoid that situation, what government stepped in and said, we are ready, we are protecting our employees by paying 80% so that you don't have to make redundant these employees. And even at this stage, what we have to look at it, the employees' rights are absolutely protected. I emphasize this word, absolutely protected. When you select people, those who are be followed, they cannot discriminate. The employer cannot discriminate on the grounds of the age, caste, religion, maternity rights, and so on and so forth. They cannot, or maybe sex, race, or nationality, they cannot discriminate in the selection process. And even now they have issued a guidance whereby the employer, the employee face any concerns, whether while they're sitting at home, working from home, or they're furloughed at home, if they feel that they have been discriminated, they still can raise their concerns. The ACAS Code of, we have an agency between the employee and the employer, like a mediator, middleman. It's a statutory body. We call it ACAS. ACAS almost every week, if not almost every fortnight, 14, maybe 3 to 4 weeks, they issue guidance as to how the employees and employers should behave. But in the event, if an employer is discriminating their employee, the employee still can raise the grievance to the employer. And ACAS has again issued another guidelines to the employees as to when to consider the grievance proceedings. If a grievance proceeding has been logged in by an employee, the employer has to consider at its utmost responsibility as to whether we can carry out a fair and proper grievance procedure. I mean, investigate the matter. How can we investigate it? Do we have the resources? Can we meet an employee when they are furloughed or when they are at annual leave? Can we investigate? So the question is, in the British employment regime or employment law regime, I am of the view the employees are better protected, relatively speaking, compared to India or compared to Middle East. And the harassment within the working environment, and even the employee if the employee are of the view that we have been selected unfairly, they still can raise concerns and grievance against the employer. And if the employer has failed to follow the procedure, when the matter gets to a tribunal, the tribunal can award a 25% uplift of the compensation in total in its entirety, because the employer had failed to follow the employment procedure, the employment practice. And the redundancy scheme. If employer wants to redundant an employee, the question arises whether the employer can afford to pay the redundancy payment to an employee. If employees are rich enough and they have the resources to pay them off, they can go for a redundancy because the statutory redundancy criteria has been met. And another option employer can do is employer can lay off. Another issue, as you all know, employer and employee relations are entered through a contract of employment. Now, at the time when you're entering into an employment law contract, you have this contract that I will pay you £1,000 a month. And now you have come to a different scenario where you are not able to perform that contract. Now you're saying I'll only pay you 80%. If the employer is going to tell them that I'm going to pay you 80% of your payment, as a clear breach of, it will become an unilateral breach of the contract. Because if a unilateral one part, if employee is not agreeing or accepting that I am ready to accept 80%, and the employer were to give them this 80%, it's a fundamental, the repudiatory breach of the contract. And the employer then can move a claim, employee then can move a claim to the employment tribunal. The question arises here. If that were the case, how will the employment tribunal look at it? When a tribunal considers an unfair dismissal, the question is, was it reasonable in all circumstances? The question arises here is whether in the given scenario, the economic circumstances, and when we are facing this catastrophe, have the employer done reasonably? That has to come through judgments which we will face in the future. And what we are facing now is all employees are approaching employees. Can we mutually amend the contract whereby we can pay you 80%? If they were to agree, issue is resolved. But if they are not going to agree, there will be a problem. Now, now they have issued a guidance as to the phase return once they are followed, and how they can come back to work, and what is the phase, and what is the procedure. And even when you ask employees to come, the requirement of them to come back to work has to be fair, must not be discriminated. And can you tell me how long more I have, just for an idea? All right, okay, in that case, I'll take questions. I'll be more than happy to take questions.